Our first lecture today is entitled An Insurer's Perspective on Malpractice Litigation. It'll be given to us by Mr. Bartley Miller. We feature this lecture by Mr. Miller because med malpractice liability reform remains a legislative priority each year. It has absolutely nothing to do with the fact that Mr. Miller was a former starting offensive lineman for the national championship winning Georgia Bulldogs. Go Dogs. So Mr. Miller is partner at Sterling Seacrest Pritchard. They had a table outside throughout this meeting. Hopefully you had a chance to go visit. He received his bachelor's degree at UGA in the Terry College of Business. He majored in risk management and insurance. He was named partner at Sterling Seacrest in 2010. And Mr. Miller offers insurance solutions for professionals with a particular interest and expertise in the healthcare industry. Welcome, Mr. Miller. Thank you.
Mic on? Oh, yes it is. Good morning. Dr. Woodham, thank you for your introduction. It's a pleasure to be with you all this morning. Again, Bartley Miller at Sterling Seacrest Pritchard. I've been lucky enough to be at this meeting for a number of years. I just shared with Kate a minute ago, I think this is the first time I've been at the 7:30 Sunday session. So it's good to be here. And a heavy topic to talk about here on a Sunday morning early. But enjoy your breakfast, and hopefully you'll get something out of this. So the purpose of this is really to give you an idea of what's going on within the med mal market. There is a lot going on, unfortunately, and really a lot of things are really unknown for the next 48 months as it relates to the impact of COVID. And so I'll get into some of those details. Let's see if this will work. Boom. All right, I'll start with a disclaimer. I'm not an attorney. This is not legal advice. Don't accept this as legal advice. Please talk to your attorney. Nothing better than coming from a risk management folks. So I think it's important before I start, everybody understand where I come from or what my relationship is in the insurance market, because it is unique. We titled this An Insurer's Perspective. I am not the insurance company. Don't want to be the insurance company. I sit in the middle of this tripartite relationship, and that is of the physician, the insurer, and the attorney. So if you look at any med mal situation, buying insurance or getting defense, which is really what you're paying for in your insurance policy, this is the relationship. It's the three-legged stool, and we sit right in the middle. So our job is to advocate for the physician. Our client is the physician. That's what hat we wear. We're friendly with our insurer partners, but at the end of the day, I don't care about the insurance company. I care about my physician client, and that's what hat we wear. That's who we are as advocates, because insurance companies only will do what you make them do. They have to be leveraged. That's the game they play, unfortunately. And trust me, we deal with it all the time. And there are certainly better ones than there are certainly good ones and bad ones, but they all need some pushing at times. So the other thing we do is we will actually place the insurance. So clients come to us, physician practice, we go out into the insurance market, secure options, come back to you to evaluate those options, and then give you recommendations on what the best solution in the market is. We were lucky enough to work with the society in putting together the malpractice program a number of years ago with the doctor's company. Program is still in existence. It's had a lot of participation and a lot of benefit back to the society. But we are assisting practices with placing that insurance. And then on the attorney side, So sometimes attorneys need a little kick in the tail, and they get that from the insurers. They also get that from us, and then also the insurers need a kick in the tail when the attorneys are saying, hey, they're not helping me get the job done or do what's in the best interest of the physician. So we play a role in that relationship as well. All right, so let's talk about litigation trends and claim trends in the market. So these are the national trends over the last 25 years. The blue bars are the number of paid claims. So this is National Practitioner Data Bank information. So this would be settlements, verdicts. Any paid claim is represented there. You can see those blue bars have been declining really and since 2001, which 2001 was kind of our last med mal crisis. Many of you were in practice during that time. So we have seen a steady decline in the number of claims paid throughout the country, which is great. So frequency is down. You can see that red line is severity. Severity continues to increase, and that is the average paid on a per claim basis. And that makes some logical sense, right? You're going to have some inflationary change, healthcare costs, life care plans, especially as we deal with brain damage in infant cases. But that has been on the steady incline. You can see 2020 and 2021, these numbers are a little unique. The courts were shut down significantly during COVID. We've had a lot less claims filed, and we just had less activity from a litigation standpoint, so we will see what the end result of that. I can tell you just based on my experience, and I don't have data to support this, but over the last 5 months, we have seen a significant increase of the number of complaints filed. I mean, at our office, we're receiving lawsuits like crazy, and a lot of activity there. All right, you look at Georgia. So same information. You can see one of the concerns here is frequency is actually up. We've seen more paid claims, but then the real concern is that severity number. So that blue line is the severity compared to the national per defendant paid claim severity. And you can see in that 2020 year, you're talking about a $250,000 difference, right? That is not insignificant. And we'll get more into the details of that as well. There we go. All right, so this is claims over $1 million, and we're going to spend a lot of time this morning talking about severity and what's going on there, but you can see there's been a steady incline of the number of paid claims over $1 million throughout the country. And then you look at that same information related to Georgia. If you look at 2011 with 5 claims over $1 million, 5 paid claims over $1 million. In 2011 versus 2020, where you have 22, that's what, a 350+% increase, right? It's a significant increase in the number of large claims that we're seeing. All right, so let's look at the Georgia claim severity. So what I've done here is we've bucketed it in 5 years, and it's because you're going to have years that are kind of off. And if we look at it from an average perspective, so this is the per defendant paid loss severity across the U.S. So same information we looked at a minute ago, and again, you see the steady increase from 2002 to now 2017 and 21. This is obstetrical related losses. So this is taking out the all claims bucket and just focused on obstetrical losses. You can see severity is higher than what you would expect on the average side, which makes sense, right, based on potential damages in obstetrical cases. And now you look at Georgia. This is the average in Georgia, and you can see the significant change compared to the national averages from a severity standpoint. Oh, I'm sorry. This was the obstetrical related U.S. Excuse me. The last one was obstetrical for Georgia. And then you can see this is Georgia with obstetrical related risk. And actually that number, you see $888,000 for severity in Georgia in that 2017-21 figure. The obstetrical severity for 2021 was, I believe, $1.3 million. So we have seen a dramatic shift upward. Now, at the same time, those 2021 paid claims, I believe there were only 5 paid. So, whether or not that's going to continue at that severity level, we'll see. But it was significant. All right, so one of the things we try to look at is, okay, of the paid claims that are, of the claims that are being paid, what percentage of them are being paid at what levels, right? And so you can see here, this indicates those claims, the percentage of claims paid above $1 million, between $500,000 and $1 million, and between $250,000 and $500,000. And obviously concerning here is you can see that red section is getting larger. And really concerning is that the 2018 and the 2021, that's 20% of paid claims over $1 million. That's a very significant number. So 20% of the paid claims in those years were over $1 million. That's a dramatic change, and frankly, one of the things that has the insurance market, the insurance carriers, very concerned about the future, especially in Georgia.
Was that OB and GYN, or was that all?
That was all. Yes. Yep. Settlements and verdicts. All right, so one of the things everybody always asks me is, all right, how do we compare to our peers around the Southeast? So going back to the 2020 numbers, this is the paid loss severity in Georgia at 657. You can see the rest of the Southeast here. We are number one. And it really has the insurance market concerned about doing business here, to be frank. And we are starting to see action by the insurers in the state of Georgia that are more significant than we see in other parts of the Southeast. All right, and you compare these numbers to the last med-mal crisis, right, in the early 2000s that we saw. Everybody can remember what premiums you were paying in the early 2000s. They were significant, much higher than you pay today. This is what the comparison of severity looked like. Obviously, a significant difference. All right, if we talk about frequency, when frequency and severity are both bad, that's when we run into problems, right? Because frequency is going to drive expense from a legal perspective, right? The more claims we have, the more dollars are going to be paid out in legal expenses. So you can see here in 2020, we had 203 paid claims in Georgia. What's a little bit off there, though, is 2019 and 2018, you had 263 and 270. So these 2020 figures, are they accurate? Will that trend stick? Then we had the COVID effect. We've seen the COVID numbers go down. We fully expect to see these numbers continue to escalate. And frankly, if we look at frequency, the number of paid claims, we expect Georgia to be in the next, 18 months to be back where we were in early 2000s, which is significant, especially with the severity that we're tying to it. All right. So talk about nuclear verdicts. Does anybody, and I ask this question all the time, think about in your head real quick what the largest civil verdict or kind of the most infamous civil verdict that you can remember. What comes to your mind first? The one that comes to my mind first is the McDonald's hot coffee case, right? Everybody remembers the story of Mrs. Liebeck, who went to a drive-through with her grandson, got a cup of coffee from McDonald's. There were no cup holders in the car. They pulled over into a parking spot. She put the cup of coffee in between her legs to put cream and sugar in it. It spilled, and she had third-degree burns in her groin area. Everybody talks about this case because McDonald's was found 80% responsible or liable for the damages. And that was $3 million is what was paid in that case. And this is one of those cases that everybody talks about, equivalent to roughly $5 million in 2021. Let's talk about what's happened in the med mal space just since 2016. So these are cases in excess of $10 million, and again, comparing us to our peers in the Southeast, and the big winners, Georgia and Florida. The concerning part about this chart is not only do we have 12 verdicts in excess of $10 million, but we are basically half of the size of the state of Florida from a physician population perspective, certainly from an attorney population, right? There's studies out there all over the place that say, hey, listen, the percentage of claims filed and the outcomes from a med mal perspective are really centered around the number of plaintiff attorneys that live in the community. Florida has more plaintiff attorneys than any other state other than maybe New York and California. But this is very concerning. So if you look at this number, you're talking about 10 or 12 cases paid over $10 million. It's a tremendous trend. And, you look at the rest of the Southeast and you say, okay, well, why are these other states not experiencing, significant verdicts like this? Well, a big part of it's tort reform. So you look here, North Carolina has what would be deemed successful tort reform. Same thing with the state of Mississippi. Now, other states on here, Virginia, Louisiana, Tennessee, they do have tort reform and parts of it that have stuck. But it's not quite as meaningful as we see in Mississippi or North Carolina. So as you talk to legislators, if we talk about involvement with the society and supporting an initiative, there is not a single specialty in the state of Georgia that will benefit more with tort reform than you and all of your obstetrical partners. It is a significant issue, and we continue to be frustrated by kind of the lack of movement that we see as it relates to tort reform. All right, so I often get asked the question, well, okay, great, we've had all these $10 million verdicts, those are all hospital losses, that's not a risk to me, and oh, by the way, those are all Atlanta losses, right? Those only happen in Atlanta, that won't happen to me in my small town, et cetera. And generally, it's true. I mean, certainly Metro Atlanta's as a venue is a lot tougher than other places in the state. But here's kind of a heat map of where we've seen some of the largest verdicts in the state. And Chatham County, Bibb County, I would argue that Bibb County right now might be the worst venue outside of Clayton County and Atlanta. Macon has gotten really hit hard. And we've seen a lot of activity there. If you look in Atlanta, the biggest concern, I would say, of the metro Atlanta area other than Clayton would be Gwinnett. We've seen a dramatic shift in Gwinnett over the last, 5 to 6 years, where historically it was a really good venue, and now it's frankly a pretty tough venue. All right, so what has all this earned us? So in the American Tort Reform Foundation puts out a report every year they call the Judicial Hellhole Report. And Georgia made that list for the first time in the history of the report in 2019, and we have remained on that list since that time. Of note, this year they make a note about apportionment and the fact that the Georgia Supreme Court found against apportionment in the state, and that is sort of true. Basically, what they said is if it is so let me back up. The 2005 tort reform bills included what is called apportionment. So the example would be if 3 physicians are named in a suit, and let's say a hospital and 3 other corporations, when the jury gets the verdict slip, they assign or apportion percentage of fault to all of those parties that are involved in that case. Okay, so they can say, hey, 10% goes to the practice, 20% goes to the physician, 10% to the PA, et cetera. That's a good thing, right? It's appropriate because before, if one party was found guilty, both parties are guilty, right? So it needs to be apportioned. The other time this comes into play, and specifically in radiology is a great example, we'll often get involved in cases, and through discovery, radiologist isn't named on the front end of a case, right? And then 3 years into the case, we realize that, hey, this is really a radiology issue, right? The radiologist didn't provide the right read or diagnosis based on the read, and it wasn't communicated to the surgeon, whatever it may be. Well, if the statute of limitations has run on that case, right, and that radiologist now can't be added as a defendant in that case, right, they become a non-party to that litigation. But they, under the apportionment rule, they can be given a verdict slip that still has that radiologist on the slip. So the jury can award damages to that radiologist who's not involved in the litigation. Does that make sense? So you could have 70% of the fault in the courtroom and the verdict apportioned to that radiologist, and they don't pay anything, right? But it helps protect those parties that are involved in that litigation. What the Georgia Supreme Court shut down was if it was a singular party that is sued, they couldn't bring a non-party in to apportion damages, right? Now, Governor Kipp has turned around, rewritten the law that pushed through, and we think apportionment no longer is an issue, and we'll continue to see it stay. I can promise you that the hospital systems have jumped on this issue big time, because what they don't want is they don't want a plaintiff suing the hospital, deep pocket, right, and then going to the involved physicians and basically saying, I will keep you out of this litigation if you join with me and support me in my litigation against the hospital, right? Creates a pretty big target on their back. So we think that issue is solved. All right, so let me walk through some of the considerations on, okay, why are we seeing these severity trends? I mentioned this earlier, but, you know, healthcare costs are going up, life care costs are going up, right? The plaintiff attorney is coming into the courtroom and claiming, hey, we need, you know, $2 billion to care for this person for the rest of their life, right? And we're continuing to see those numbers go up and continue to be supported by experts. You know, frankly, we've seen a pretty soft insurance market. For those, again, that have been around a long time, I mean, we saw OB premiums go way low historically, right? And what happened with that is a lot of physicians, all specialties, said, hey, you know what, I'm going to buy more insurance limits, right? Because this costs less than what I used to pay, and you know what, I'm going to have a little bit of added protection. I'm getting later in my career. I've got assets to protect, et cetera. So what has that caused? It has caused some additional limits to be in play within the insurance market, right? And we all know two schools of thought related to the plaintiff attorneys. They're going to go after either A, the insurance limit, right, or B, in a horrific case, they're going to go after whatever they can get, right, which could be excess of the insurance limits. But the more insurance limits at play, certainly it does increase value. In fact, last week I was on a conference call. We had a demand from a plaintiff attorney. I think it was, the initial demand was $3 million, and then they found out we had a $5 million excess policy that they hadn't seen before, right? And next thing we know, we got an $8 million demand. And it's like, well, a couple weeks ago you thought this was a $3 million case, now you think it's an $8 million case, I wonder why, right? But they have access to that information. All right, so courtroom considerations. You've probably heard other attorneys, attorneys talk about this. The reptilian brain theory, really the concept there is plaintiff attorneys have used this as a new way of really invoking jurors' primal instincts to protect themselves and to protect the community. And this has kind of become its own little science and really worked at by plaintiff attorneys. And that is, they go to the jury and they say, hey, you know, not only did this person get harmed, right, but we want you to protect the general public by teaching this hospital, this physician a lesson, right? We've got to change the industry. So anybody heard about the $1.7 billion verdict against Ford in Georgia, right? that's this concept, right? It's going to the jury and saying, hey, yeah, this couple got injured, right? But we need you to teach Ford a lesson so they'll change their ways, right? And that's what they're utilizing in that reptilian brain theory. Juries are just desensitized by money. I think the biggest example I can share there is LeBron James. I mean, he's making a ton of money, right? You see those kind of contracts, right? You see professional athlete contracts, and juries are like, well, what's $100 million, right? That's what's scary. Changes in jury polling. So in Georgia, historically, and this has changed 5, 6, 7 years ago, but historically we had polled jurors primarily based on voter registration. Now we're polling primarily based on driver's license registration. And that has changed the jury polls. And really, like Gwinnett County is a great example of that, where we historically saw a very conservative venue from a defense perspective, and now it's gotten much more aggressive. This clicker. There we go. COVID backlog, we'll see how that plays out, but we certainly are behind in the court system. Any of you that have an active case, unfortunately, buckle up. It may be a while before it gets resolved. It took a long time before, and now it may even take a longer time. So plaintiff representation. So a couple things I want to hit on here. So number one, we're seeing better quality plaintiff attorneys that are litigating malpractice cases. And I think a lot of this, has anybody seen an attorney billboard, right? Yeah. Okay, so those billboards, really what these large law firms have turned into, they're marketing companies. They're not law firms, right? They are trying to capture cases, right? And then those cases can be funneled to whatever attorney they want to handle the case. So what's happening in the med mal space is, historically we would see a local attorney who maybe did a auto loss liability claim on Monday and then defended the flower shop or sued the flower shop for somebody getting stuck with a rose on Tuesday and then try a med mal case on Wednesday. We're not seeing that anymore, right? We're seeing these cases get funneled to attorneys that are much more savvy. They understand medicine. Any of you guys that have been in litigation, you understand that these attorneys, the defense attorneys that represent you, for the most part, all of them, they got a pretty good handle on medicine at this point if they've got good experience, right? And so they can somewhat speak your language, which is a good thing. But we're now starting to see that on the other side. The biggest issue we're seeing, though, is the plaintiff attorneys are not scared to try a case. Why? The reason is because there is tons of money flowing to the attorneys to say, hey, we want to invest in your cases. So we call it litigation funding, right? So there are companies out there, and the numbers are, I believe 5 years ago, it was like $1 billion industry, and now it's a $30 billion investment industry. It's just increased dramatically. So what these venture capital firms are coming in and saying is they'll say, hey, we want to pay for all the treatment related to your client, so the injured party. We'll pay all the physician expenses. Some of you know physicians that are in this market, right, making a lot of money, working with plaintiff attorneys, taking care of their patients. It's happening all the time. They will front in money to the injured party, and then they'll say to the attorney, hey, you need $400,000 to try this case, to invest in the case, to get the right experts, to get all the presentation material, et cetera. We got it. But we're going to take a cut on the back end, right? Well, historically, that plaintiff attorney would have to go borrow money from the bank, find $400,000 to invest in that case, and they would have agreed to settle it maybe before they go to trial, or they may have dropped the case altogether because they didn't feel like they could win, right? Well, that's changed significantly. And if anything that I think is driving up severity, it's this. We are seeing issues from a time demand standpoint, which has really led to a lot of bad faith issues in the insurance market. And that is the plaintiff attorneys have gotten smart. They're basically coming in and right off the bat, they're saying, hey, you've got 3 months and here's our demand. If you don't pay what we want, we're going forward with litigation. And unfortunately, the insurance companies, and it obviously depends on the company, some of them have run scared to that. right? Because they're worried about the severity. And the challenge is you may look at a case on its face and say, ugh, this is really bad, right? It doesn't look good. The care's not great. There's complications, whatever it may be. But the reality is you don't know what a case is worth until you get all the way through discovery, right, and really start prepping for trial, because you don't know what your expert support is. You don't know what their expert support is. You know, we've had cases over the years where things have come out as the case continues to drag on that are slam dunks for us, right? So running to go settle a case is dangerous, right? And unfortunately what you're doing is you're training the dog in that perspective, right? You're telling the plaintiff attorneys, hey, put a demand on us, and we're going to write a check. And that is not good for the market. All right, I got to hustle through some of these. So we all know healthcare is changing. There's been massive consolidation. I will tell you, I think some of the severity also is there's a bigger target on some organizations' back, right? We all know the health systems have gone from smaller employed physician populations to now really large employed physician populations. The private equity investment in healthcare, we represent a ton of them. It has changed the game just as far as what funds are there, regardless of insurance, to go after. There are access issues, especially in obstetrics. We've seen claims associated with obstetrical units shutting down in smaller towns. I will tell you the insurance industry, in my opinion, is partly to blame for what we're seeing right now. And I think a lot of it has to do with insurance companies from 2005 to 2015 made more money than they've ever made in the history of our industry. I mean, a lot of money, right? Now, I can tell you, prior to that, during the early 2000s, they lost a lot of money. But they made a lot of money. And I think what has happened as a result of that is I do think there's been a lack of investment on the claims side to a certain extent. And I think it has resulted in claims handling not being done as well as it's been done in the past. And I'll touch on, I can touch on it here. The other concern I have is the defense attorneys that are handling these cases, the malpractice companies are not paying them what they really should get paid. I mean, these partners in these firms are getting paid, low $300 an hour, right? Some of them are getting paid less than $300 an hour. If you go to King and Spalding and talk to one of their partners, they're making $1,300 an hour, right? That's the difference, right? So then you worry about, okay, well, who's going to be defending me and what kind of quality of attorney are we going to have, right? That's a concern too. We've also seen massive expansion from the insurance companies, and frankly, a lot of that has to do with the shrinking physician population, and that puts a strain on any business, right? Trust me, we've grown. When I joined our firm, we had 14 employees. Now we have over 300 employees, right? And I've felt it. Growth is great, but there are struggles that come with that, and the insurance company has felt those struggles. All right. All right, so combined ratios. So now what I want to talk about is, all right, how's the insurance world performed? How have the insurance companies performed? So the combined ratio is, this is the easiest way to think about it, total expenses of the insurance company, claims, paying underwriting, paying risk management, et cetera, all expenses of the insurance company divided by their written premium for that individual year. If it's over 100%, theoretically, well, not theoretically, they are at an underwriting loss. Now, it doesn't mean that they're losing money, right, because they're getting investment return on their surplus, right? But anything over 100% is, concerning, right? Now, if an insurer's running at 107%, are they losing money left and right? No, right, because they are getting investment income. But you can see this is how we're performing, and these are aggregate numbers looking at the entire industry. You can see Georgia over 115%. I think there's many that would tell you that could be upwards of 135% realistically if you looked at all the insurers. These are the four that I refer to, the big four, and these are the four insurance companies that have the majority of the market share in the state of Georgia. And you can see all but one are over 100%, right? And this is kind of what we're talking about of the trend that we're seeing from a loss perspective. MedPro is under 100%, and when you see the OBGYN premium, you'll understand why in a second. But overall, we're starting, I think we'll start to see these numbers level off a little bit as rate, because all of you have seen rate passed on, right? I mean, your premiums have gone up over the last 2 years. So hopefully we'll start to see this level out a little bit, but those are the trends we're seeing. And then, so in the state of Georgia, with a standard insurer, they file what are called base rates in the state of Georgia. So it's really a consumer protection process where the company says, all right, this is what we're going to charge for an OBGYN, but it's not what you pay, right? So I want to make sure everybody understands these numbers up here are not what you pay, because you get discounts off of these numbers to pay whatever your ultimate premium is. But these numbers are provided to the state insurance department, and they substantiate what they believe the insurance company's exposure is, or what their rate need is based on each specialty, okay? And you can see we've seen a steady incline across the board with the insurers. I do want to point out, Curie, frankly, they have not played as much in the obstetrical space, so you see that their trend is lower. You could argue that it's because they haven't written as much in the obstetrical space, but you can see a steady incline there. Those are Metro Atlanta rates, by the way, just to point out. All right, so a couple kind of closing comments on the insurance market. So overall, we have seen the trend upward in cost, right? Up 22.9% from 2021 to 2017. That's an all-time high from an increase perspective that we've seen in the last 10 years. I'm just going to click all these. So of that growth, hospitals represent the largest growing segment. So we also work with health systems and represent them, and I can tell you that there is a big strain on the hospital side as well on a professional liability perspective. And frankly, a big reason for that is there's really become limitations related to capacity in the hospital market. There aren't that many players. A lot of players have gotten out. So it's a much more limited marketplace for hospitals as purchasers. So there has been a significant reduction in the what I would say insurable pool for physicians. As all of you know, there's been a push for hospital employment. There's been roll-ups. And a lot of insurance companies have been put into a situation where the pool or the pond they swim in, right, has shrunk dramatically from a market perspective. So what has that resulted in? It's resulted in either A, the insurance company having to differentiate, right, and do things that they historically haven't done, i.e. a physician insurer now starts writing hospitals, starts writing chiropractors, et cetera, right? Or they've had to expand, right, their footprint, right? So you've seen a lot of insurance companies start to go across the country and grow. And as I shared earlier, that can be great because it's building up capital for the insurance company, but at the same time, it can cause some constraints and certainly some frustrations along the way because growth is not always easy to manage. I touched on this a minute ago, the continued pressure to manage expenses. I do have concerns about the next generation of defense attorneys in the state, and I don't mean that to say that there's not a bunch of really high-quality defense attorneys in Georgia. But I will tell you, as I look and sit there, and as a younger person in this industry, I kind of go, all right, who's the next generation, right? Who's going to come to fill the shoes of the John Halls, the Paul Wethingtons, the Dan Huffs? Who's going to be next, right? And I think a big concern I have with that, too, is that the insurance companies, in order for them to be ready, they've got to try cases. And they're not getting the chance to try cases. So if you can't train them in the courtroom, how are they ever going to be able to represent a physician on their own, right? Come on. All right. We are starting to see a push to limit capacity in the insurance market. So, we've had groups that have historically carried like a 5 million, 8 million limit on a per physician basis. There are insurance companies that are now saying, we don't really feel great about that with the severity trends in the state, or our reinsurance treaties won't support it, et cetera. So we're starting to see a pushback on that to say we're not comfortable with releasing that type of capacity. We're also seeing a move, some of you may know, but there have been insurers that have offered limits on a mom and baby basis. So traditionally in the insurance market, you get $1 million worth of coverage for a claim, right? And in obstetrics, unique to obstetrics, you can have a suit where the plaintiff is the mom and the baby, right? And with some insurers, they have historically offered $1 million limit for the mom and $1 million limit for the baby, even if you carried a 1 million, 3 million limit. Does that make sense? Well, now that offer is still out there, but they're starting to add premium dollars associated with it. So they're going to charge you more if you want that benefit. Now, we could argue, is it better to have it that way or not? It depends. It depends on the case of whether you want that, frankly. But that speaks to the pressures that are coming out there on capacity, right? Because that's an additional $1 million limit that the insurance company's putting out there, right? And with the severity trend that we're seeing, it's not insignificant. Same thing on corporation limits. We're starting to see costs go up dramatically for the charges for practices and corporations carrying their own separate limits, and then excess. If you're trying to go out and get a $5 million, $10 million tower of limits over professional liability, it's not fun. And I always get the question, some of you may be thinking about this, man, I hate insurance companies. Let's start a captive. I'm with you. I'm in. Let's do it. The problem is getting the reinsurance placed on a captive in the MPL space in the state of Georgia right now is very difficult. And that's the reason you're not really seeing that activity happen right now. We do expect to see consolidation in the insurance market. And I think you're going to see the big insurers get bigger. There are some insurers doing business in the state of Georgia that frankly do not have the financial backing they need to live here long term, especially in a bad market. And I think you'll either see them gobbled up or you'll see them go under. And I think I will say you really need to be mindful as a consumer that there are a limited number of insurers that really do this at a high level, that are going to provide you the quality defense you need, right? Are going to work with the best attorneys, are going to have all the policy provisions that you need, and that are going to have the financial support and solvency to support you on a go-forward basis. And here's the problem in obstetrics. So everybody knows, you bring up tail, and everybody gets worried, right? But an OBGyn tail in today's med mal market could be, anywhere from $125,000 to $175,000, right? One-time expense. That's not insignificant, right? The challenge when you get with any of these carriers that have the risk of going under is if they do go under, you're at risk of having to stroke that check in order to have any liability for your past exposures. So it can be an expensive mistake. So you got to be a good consumer and think about where you're going. We are seeing tightening of underwriting guidelines. It's no longer 2015, which I said was the wild, wild west, where it's like, I'd say company A, all right, give me your price. Okay, company B, this is what company A's at, match it. They'd go 10% down, then the next one would go 10% down. That's not the market we're in anymore. I think we're going to start to see insurers utilize big data. I think we've already seen this kind of looking behind the scenes, that they're starting to evaluate commentary on physicians online, as an example, to rate physicians, to see whether they are a poor exposure or not. And a lot of that has to do with trigger words and comments, like disrespectful, doesn't have time for me, those big ego, those type of things that insurers may begin to look at. And then a lot of insurance companies right now are trying to find ways to continue to support independence, right? They're making investments in all sorts of ancillary services really outside of insurance to try to support physicians remaining independent, and we will see how those continue to develop. And I talked about kind of control and volatility. All right. So I just want to thank the panel yesterday on this topic. I was going to come in here and try to review this bill, and thank goodness I don't have to do that. So thank you. I was nervous. I think I mentioned this to a few folks yesterday. I want to hit on a few key points, and I really enjoyed that session yesterday, and thank you all for putting it together. So what's the insurance world or insurance market's response been to 481? I will tell you it's been really kind of delicate and slow to respond to this issue, especially publicly. The insurers understand fully what the issue is, and they don't know how to fix it, is really the truth. And there's been a lot of conversation. We actually had a think tank with two companies a while back, kind of right as this was rolling out, and it's a problem in the insurance market. One of the reasons they've been quiet is because you don't have any insurance for criminal acts under your malpractice policy, and that applies to all of them. So if there is a criminal act or a criminal action taken against you and you're charged criminally, the MPL policy is not going to provide defense costs related to that criminal case. And if you really think about it, it's really tough to decipher what is intentional and what is not intentional on this issue as it relates to criminal acts, right? And that's why it's going to be really tough, I think, for the insurance market to try to navigate this and try to provide physicians. I can tell you, I was talking to one of the VP of claims last week, and we were kind of kicking around some of these issues, and he said to me, he's like, look, if we get involved in a case with one of our physicians and that we have some crazy DA who's just going after him, we're going to stand by our physician. You know, we're not going to let that happen to them, right? And I think he is absolutely being truthful and would support that. The problem is it's not in the policy. So it's going to be interesting to see how carriers respond to this issue. I do think, and a lot of carriers have come out and said this publicly, I think if you get into a situation where there is an allegation of unprofessional conduct, which was part of the law, I think they will stand by you and support you as it relates to the medical board or any other government-related agency as it relates to an investigation. It's just the criminal component that they're going to step out of the way on. All right, so this really got, everybody went through this yesterday, but did my mic go out? Oh, there we go. Sorry. I want to touch on a few key components and just give a few recommendations. So obviously the two key points here from a risk management perspective are, all right, what is a medical emergency, right? And what is the definition of medically futile, right? And how do we support those decisions when it is time to terminate? So Dr. Perry said this yesterday during the panel discussion, but the number one risk management piece of advice we can give you is documentation. Documentation of your decision, your thought process, the reason the mother is at risk, right, of death or significant impairment, or why you believe the pregnancy is medically futile is going to be critical in the defense. And that's all malpractice, right? But this is going to be a little bit broader, and I would just tell you, in the event these situations come up, you want to really be thoughtful about your documentation, right? And the other thing I would tell you is you can correct documentation, right? But you can't change it, right? So we can do addendums to notes. That's not a problem, right? It's not an admission of guilt to say, hey, what I wrote yesterday was not absolutely accurate, right? But you can't change it. Don't change that original note. Look, the metadata in EMRs now are going to follow that anyways. It's going to the attorneys are going to find that out in e-discovery. So don't be afraid of making corrections via addendums to those notes, and they are appropriate. And I'll touch on one other piece about that in a second. So this was kind of touched on yesterday. You know, in the med mal world, we talk about standard of care. What was the standard of care owed to this patient? The standard of care is not, you know, clearly defined, right? It really has to do with more of the environment, right? What was available to the physician, you know, what were the patient circumstances, et cetera. And so that is often argued in the courtroom, right? And I think standard of judgment, you know, standard of care, we're going to be in that same situation here, right? Was that judgment considered standard based on the law? The problem is we don't have anything to support this yet, right? And the law is so vague that it's really impossible for us to know what is and isn't. And it got brought up yesterday of, you know, ACOG putting together a list and ACOG saying, no, we don't think that's right. And I agree. I don't think it's appropriate to put together a list to say, okay, this you know, meets the definition of medically futile. This meets the definition of emergency. And the reason I say that is because every situation is different, especially in obstetrics. And you have that list, now you're just arming the DA or a plaintiff attorney as it relates to that care. So I actually think that's the right play. I think it'll be interesting to see where EMTALA and 481 intersect. You know, the attorneys would tell you that EMTALA is going to be enforceable over state law, right? Some of the two largest verdicts or settlements we've seen related to EMTALA investigations is related to, you know, a hospital making a decision on state law versus federal law, right? And I think the federal government's going to step up to the plate here. OIG will certainly go after any facility that decides to lean towards state law over federal. I do think there's a potential for this to create some added protection in the event of an emergent situation. I think it'll be interesting to see where that goes. And the example there would be, you know, patient comes into the ED, you then get called in to treat this pregnant patient, and, you know, you are in a situation where it is emergent, right? But that decision timeline of how dangerous is this for the pregnant patient and when can we make this decision, right? Because that's probably the biggest issue, one of the biggest issues in my mind here, and I'll touch on that next, is, you know, if we're having to delay care to a pregnant patient because they're not sick enough yet, right? That inherently is going to create additional liability, right? Because now we're just leading down the road of additional complications, right? More severe complications, a bad outcome, right? Frustrations from the patient to us to say, why can't you do something for me, right? That's the big issue here. On the emergent side, I actually think EMTALA may support you having more immediate action and a little bit more comfort in taking that action versus in a non-emergent situation. And I think what's important about the EMTALA piece is, and I think the hospitals need to do a good job of this, is making sure that their guidelines are robust and broad in what falls under EMTALA requirements for everyone on staff. So, and I think that's a conversation I'd recommend you bring up with your systems. Just touch on this. There is a moral objection actually written into 481, basically stating, hey, you know, these laws in no way require a physician to provide abortion care. And I think the piece I bring up to that is that's not an out for EMTALA, right? So you're on call and you're required to provide emergent care. You know, maybe the state law says that, but EMTALA may not support that, right? So it goes both ways, how it may apply. So The concern I have is, again, I do think we're going to see more litigation associated with this. I think we are increasing liability for physicians. I think it's made it more complicated for sure. I also have a little bit of concern with the whole consult approach. I think one of the things that was brought up yesterday is, okay, if I'm making this medical decision, right, I want to go make sure it's reasonable, and I may bring in, you know, whether it's MFM or another colleague to support my decision, right? That happens every day. Y'all do that already. But if we start to document that, right, in support of our decision, are we creating liability for our colleagues, right? I think the answer to that probably is no, because there's not a physician-patient relationship between that provider and the patient. Now, on the MFM side, there would be. But it will be interesting to see where that goes. And that's one of the questions we've kind of poked around on, because we want to give some guidance about that, right? Is that a good idea? Is that a bad idea, right? And I will tell you right now, I would generally say I probably would not document. Unless the provider is involved in the patient's care, I would not document any other provider's names in those charts. And the reason is because I think you're just asking for problems. Now, there's really no other way you can document that, but you certainly can have support with your colleagues in that decision. But I'd be careful on that right now. And I'm out of time. I found this interesting. I don't know if anybody else saw this in the law, but the duty to preserve the health of a viable child. So in the event of termination, if the child can live, you have to provide care under the law. Now, it doesn't really add up for me. I guess it could add up in an emergent situation, but understand that language is in the law, and that creates some complexity, right? Because if we have, let's say, an emergency, you step in, you're providing care to that child lives, right? Now we're dealing with a complex potential risk, right? Because if that child lives and has impairment, we're in trouble, and we've kind of jumped into that sandbox. So we're trying to get a better understanding of really why that's in there. Because if you can only abort for the two purposes, you know, obviously prior to or after a heartbeat is detected, that one doesn't make a lot of sense to me. So, all right. Any questions y'all have? I know that 7:30 in the morning, hearing about getting sued, this is just what you guys want to talk about.
Any questions at all? Yes. Is that mic on?
No? Okay, sorry. I'm Cassie Campbell from Athens. I was just curious, talking about the increasing payouts that we're seeing. Do you think that has any reflection on the kind of attention that's been focused on jury profiling? I've been really appalled that some of these plaintiffs' attorneys, they're bringing in like hundreds of people. Here's your $200 gift card and your lunch, and let me tell you about a case and see what you think about it. I'm like, how is this not just basic, age, race, socioeconomic status, but very specific case? And I just wondered if that's why these handouts are so much bigger than they used to be.
Well, I mean, I think the number one, pre-trial, what the plaintiff attorneys are doing to try to figure out what's going to play to a jury is certainly had an impact. And that's kind of what I was talking about with the more kind of better plaintiff attorneys that are trying these cases. They're really getting into, all right, how can I invoke an emotional response from this jury, right? And how do I speak to them, right? So that's happening. I think some of it's just societal. I think, what frustrates me more than anything is I grew up in a household where a physician was a doctor, right? And they were looked at in a different way, right? And I can remember the first time I went to a friend's house who had a parent as a physician, and my dad said to me before I got out of the car, he said, "It is Dr. Williams." And I was like, "Yes, sir," right? And so I think that has changed in society. And I will say there's some arguments out there that maybe COVID will flip the script on that a little bit and hopefully have society appreciate physicians a little bit more. But I think that's one of the big problems, frankly.
Hi, I'm Gretchen Coons from Atlanta. Quick question. So I'm the medical director of a big MFM group in Atlanta. And us, as well as other people around the state, are seeing less and less physicians. So we take a lot of curbside consults from all over the state.
Yep.
And I have two very young partners just out of fellowship that refuse to answer questions on a patient they've never seen because they're scared to death of liability. And we have been told that that patient-physician relationship starts when any physician calls us. So my name gets documented, somewhere in Georgia that I said this. I've never seen the patient. I've never seen any of their chart.
Yep.
And we're concerned about our liability.
And in your specialty, that is a concern.
And it happens
Because
10 times a day.
they're calling an expert. When I was talking to colleagues, that was more of the hallway conversation to say, hey, this is the situation I'm dealing with. They're not calling a specialist to get really clinical advice.
So what can we do to protect I keep a little black book, date, patient's name, and basically the gist of what I was told and what I said.
Yeah.
But I don't know any other way to protect ourselves because we have no way to document in a system if we've never seen a patient before.
Yeah, it's tough. I think anytime you get a call, and there has to be some reasonableness to this, but if you get a call, especially with more of a complex issue, I'd encourage you to create a chart on that patient, right? And, request the records from the treating physician and really fully document what it is you're providing them. Now, I think the other angle is, hey, we need to see this patient, right, via telemed or, having them come into the office. At the end of the day, I don't have significant concerns about telemedicine from an ongoing risk perspective because I think it has changed. I don't want to say the obligation because it hasn't changed the obligation legally, but I think in the plaintiff's mind, right, there's a different level of acuity to what they're asking you to care for. But at the end of the day, you got to do it right, and you've got to be able to provide guidance on that patient with the information you need to do it. And I think MFM is one of those specialties where, telemedicine has taken off significantly, and it certainly adds value.
Thank you.
It's tough. I wish I had a better answer.
So we're not architects and we're not attorneys, so we don't get paid for answering the phone and starting the clock,
Yep.
or answering a text. And I've had about 4 or 5 of those this weekend. What should I do in this situation? And these are relatively uncomplicated patients. So 2 scenarios. As a consultant, I do put a note in the chart, and we had a case a few weeks ago with 26 weeks, non-immune high drops, everything swollen, and there's a 6-centimeter mass in the chest. And so I wrote this is medically futile and advocated for delivery. But again, that was primary OBGyn asking for a consultation. So the reason I came up here is because you talked about not implicating the other person in the chart. Well, our hospital has told us, our very large hospital system has told us that we need to have 2 physicians sign off in order to be able to proceed. So this was a 19-week, 6-day premature rupture of membranes case in which, interestingly enough, 2 years ago, she came in at 19 weeks and we induced her labor and delivered her, and no one batted an eye with that. So here we are 2 years later under these circumstances, and I was the doctor on call when this patient arrived, and now I have to get another physician to co-sign what I did 2 years ago without speaking to anyone about.
Right.
But again, we have to have 2 physicians now to sign off on it.
Yeah, and that doesn't surprise me, and I think you'll probably see a bunch of the health systems initially step in and say that, right? Because they want consensus, right? They don't want to base it off one individual physician's opinion. I do have concerns about that, though, because if you're going to sign off on that, have you reviewed the record? fully, right? Have you, how in depth has your communication been with your colleague? I think is one question, right? Because if it's like, oh, well, if you think so, then yeah, I'm good, right? That's concerning. And I think you could be opening yourself up to liability. At the end of the day, though, I think that liability is going to be limited to a certain extent, though. It always is, right? If you're just providing a consult and you're not the direct relationship, but could you be dragged in? Yeah, you could be. Because I think there's a duty owed at that point.
Well, I'm just saying they're not going to allow us to do anything until two physicians
Right.
say.
Agree.
But that's in a medically futile situation, right? That's a right. Not, but in an emergent situation, you're on your own to make a call, right? Yeah. It's tough.
2 quick comments. Thank you very much. We always enjoy hearing from you and very much appreciate your partnership. I think you're going to be an incredible ally. You, the insurance companies, as you acknowledged, hard stop, there are going to be more malpractice cases as a result of this. They're just going to be. Unfortunately, what that translates is there are going to be more deaths. There are going to be a lot more mortality and morbidity because of this terrible law. But I think the insurance companies have a wonderful opportunity to be that voice. You're the guys they're used to seeing under the Gold Dome. They take you seriously. I'm going to stop short of the deep pockets thing, but I think, we're a bunch of little bitty, nitpicky, annoying OBGYNs at the end of the day. That doesn't mean we should stop talking. Don't ever stop talking. But I hope you see your part in this.
Yep.
And honestly, I don't see any downside. There's not going to be any dirt on you at the end of the day.
Right.
You will always be on the side of right. The other thing I hope all of you take away from this, and thank you, it was like you just slid into this on that last slide. Hospitals. Your hospitals, some of them are just egregious in terms of the fact that they have not gotten on board and not come to a nice conclusion of how they plan to support you and your patients. And so I would task each of you to go back, hopefully as a department, so you've got strength in numbers, and make them sit down with you. Make them tell you. There are no answers. We told you yesterday. There are no answers. They're not going to give you discrete answers. But what do you expect from us, such that you back us up? What is it that you want? How do you want us to approach this? They owe that to you. But thank you.
Thank you
for everything.
So I got just one follow-up on that, Dr. Perry. Thank you. So I say this to my physician clients all the time, and I really just empower the folks in this room. Y'all have so much control. Babies, women in this state need you, and you have all the control. Physicians in healthcare have all the control. Nothing happens without doctors, period. And this is really those issues where it's about coming together. And I think to a certain extent, and I'd encourage you, because we love the feedback, and I got a lot of this out of this yesterday, there's always the argument of yes or no, right, related to this law. I would encourage any commentary you have clinically about the concerns you have, the risk concerns you have, the real life circumstances that you're in clinically, and can provide us that information to really support the argument of saying, hey, look, the bill is what it is. We are where we are, but this needs to get cleaned up if we're going to proceed, right? Because I am worried about the liability components, and that's not in this group's best interest. You don't need any more liability than you have today. Same issue on tort reform, too. Yeah.
There's such a thing as criminal defense insurance.
No, but I always, my response to any question like that is somebody will write it, right? We can find somebody that'll write that. It's whether you want to pay for it. But no, I'm not aware of anybody out there that's offering that for physicians. Now, different on the regulatory side, but not for that kind of criminal case. Thank you.